Boom. We're live.
There we go.
It is Wednesday, February 15th, and I'm here in snowy Denver today. And I'm joined by my amigo Matthew, who's in not snowy Ohio, I think.
Yes, sir. It's windy, but not snowy, so I'll take it.
Yeah. I mean, sometimes it's snowy and windy. That happens.
Yeah.
I have some neighbors. We were having dinner with them the other night, my wife and I, and they moved here from Minnesota. And they said that people always think they're crazy when they tell people that they moved here for the weather. It's like, yes, you could move to Denver to get better weather if you're coming from Minnesota, certainly.
Yeah.
So they're not complaining. Welcome, Connor. Thanks for being here. So today's going to be interesting. We have I think some really valid industry updates as far as things that are going on with the ATF, with potential gun registration concerns, with the assault weapon ban in Illinois, and other drama as well. So it's going to be a good discussion. We have a total of 7 kind of topics that we're going to kind of try and push through. Welcome, Scott. Thanks for being here. And like usual, Matthew's done all of the research and real back end work on this, and I just get to show up and look like I know what I'm talking about. And Riley's out today. He's just got too much other stuff going on, and so we're giving him a bow out, and we're gonna keep the fire burning.
Yeah. Excited and appreciate you guys tuning in like you normally do.
Yeah, it's gonna be good. All right, Matthew the Marine. Here we go. We're gonna get kicked off here. For those of you who are joining us live, a reminder: you can always comment. We'll see those. We'll read those. We'll try and reply when we can, but we may not answer questions live if they're off topic or not relevant to the discussion. All right, here we go. In 3, 2, 1. This is the Concealed Carry Podcast, Season 8, Episode 5. Welcome to the Concealed Carry Podcast, part of the concealedcarry.com network of podcasts, brought to you by Mountain Man Medical. Today is Wednesday, February 15th, 2023, and I'm your host, Jacob Paulson. And today I'm also joined by Matthew Marister. Hello, Marine Matthew.
Hey, Jacob, what's going on?
It's a big deal, man. Once a Marine, always a Marine. That's what they say.
That's correct.
Today we got a lot of stories we're going to cover. This is our industry update or industry news episode that we try and do once a month, and it's going to be interesting. Everyone's in major freak out mode right now about the whole pistol brace drama, and we actually have a lot of things to talk about, and surprisingly, that's not one of them. We have some other things that you may not be paying attention to that I think you need to know about that we're going to cover. So stay tuned with us. First, a quick word from our sponsors. We're going to actually do something a little bit different today. We are going to, like usual, we have 2 sponsor messages. We're going to do one of them now, and then we're going to do one of our other sponsor messages a little bit later. So that's weird, but that's what you're going to get. So first, today's episode is brought to you by the Guardian Conference. Well, listen up. The Guardian Conference, it's kind of a big deal. We're going to talk more about it in the future. We're not going to stop talking about it. So you should just, finally get out your phone or go to your computer and go to guardianconference.com and do the research and due diligence and learn about this event. It's kind of a big deal. We are really looking forward to it. The 2023 Guardian Conference is going to be the 3rd annual Guardian Conference. It's coming up this fall in September, so you have plenty of time to request the dates off from work, to plan for the babysitters, for whatever it is thing you got to do, get your hotel booked, buy the ammo, all that good fun stuff. And it's a 3-day training event where you're going to take a class every morning and every afternoon for 3 days. So at least 6 total classes. You get to choose those classes. There's plenty of gun work. If you want to be on the range all day, and I don't recommend it, but you can do that. If you want to be on the range all day for 3 days, I don't recommend it because, one, it's really stinking hot. But more importantly, because there's so much other good stuff. You can do combatives. You can be doing some kicking, some punching, some jabbing, some rolling. You can get some legal education, some medical education. We might have a couple other tricks up our sleeve that are new this year. So learn more at guardianconference.com. We just recently updated the website, so the new travel information's on there, the new information for booking hotels. We have one new group hotel that we added this year, so you can get your hotel rooms booked. I encourage you to do that as quickly as possible. And frankly, now's the time to sign up because we still have the super early bird price. To manage some expectations so people understand how this works, basically the idea is we do the super early bird discount until we finalize the list of instructors. And we do have some instructors confirmed, at least one of which is new, so check that out. But once we get the final list, hey, here are all the instructors are going to be teaching, that's generally when we take away the super early bird price, and then we go to just early bird price. And the early bird tends to last a little bit. It stays until we basically get the actual class list. These are classes that are going to be offered, finalized. Once that's finalized, the early bird price is gone as well. So get in there, check it out, guardianconference.com. Matthew, you've been to the first and second Guardian Conference. What's your 15-second thing you want to tell people about the Guardian Conference?
It's probably not what you expect. It's probably, if you're expecting, it to be just a bunch of high level running and shooting and that's all, you'll probably be surprised at the diversity of the types of classes and the people that are there. It's not just a bunch of dudes with like plate carriers and all kinds of stuff. You have families there, you have husbands and wives, and it's a great environment to learn and be able to take in a bunch of different disciplines and different things that you might not normally be able to get to. So in one event. So and it's a beautiful facility too. So
yeah, available and custom built to deliver value for people of all skill levels, all ages, all genders, all whatevers. So check it out, guardianconference.com. All right, let's dive right into it. So we're going to get into our first story here. And this one is actually published on our website, though I've seen this covered by a handful of media outlets. And the title of the story is Federal Judge Law Barring Marijuana Users from Owning Firearm is Unconstitutional. So this is a court case that seems to have gotten smacked around, and made its way up the food chain a little bit until it hit a federal district court. Matthew, what's the deal here? Is everybody listening to this? They can go smoke weed now? Is that what we're saying?
Not exactly. And obviously, I'll preface this whole conversation with, it's generally not a good idea to be high or drunk or under the influence and handle firearms, whether it's legal or not. Like, we're not talking about, I don't know what, if it's smart to handle firearms or if it's a good idea to smoke marijuana. That's irrelevant.
If you're physically or emotionally compromised, you shouldn't have direct access to a gun, and that opinion is not changed.
Right. So this has to do with, is the law that makes when you go to buy a firearm and says, are you either a legal or illegal user of any controlled substance or marijuana, is that prohibition constitutional? And the case is United States versus Jared Michael Harrison. And essentially what happens is this guy is driving his vehicle. He gets stopped by the police by failing to stop at a light. Police come, they speak to him at the car. They smell marijuana. They ask him to come out of the car. He doesn't have a medical marijuana license, so essentially he's just like plain sight, you can have plain smell. And they smell marijuana, so it's assumed that there's marijuana in the car. They take him out of the car. They find marijuana in the car. They find a loaded revolver in the vehicle, and basically what they do is they arrest him. They arrest him for possession of marijuana, possession of paraphernalia, and in the traffic violation. As he's waiting for these charges, they then file the federal indictment charging him with possessing a firearm with knowledge that he was an unlawful user of marijuana, and that's the federal 18 USC 922 G3. And so that's that prohibition that you can't, because marijuana is a scheduled drug and it's not legal, even if a state allows it. Federally, you still cannot do that, and he's in possession of it. So he can't. He's a user. He's in possession of it. Now, Harrison, the defendant here, he argues that with the new ruling in the New York New York State Rifle and Pistol Association, that recent Supreme Court case where they basically, they were addressing the New York licensing scheme that said
shall issue drama.
Right, yeah. Exactly. Shall issue. They were addressing that, but in addressing that, they really upended the way Second Amendment cases were looked at and said, hey, we're not going to put a means test and just like say, hey, what do we think? Does it seem like this law, it makes, people safer or what? Like, we're going to say, let's look at the original intent of the text at the time, and were there laws, similar to what you're trying to enforce now, and if there isn't, there's no precedent for that. Now, you can still pass laws that weren't, but essentially that we're trying to figure out what the actual meaning of the Second Amendment was when it was written, rather than how we, interpret it today. And so he says there's no history of being prohibited simply for being in possession of anything or even using something like alcohol or narcotics or drugs or illegal substances. And certainly there was alcohol back then, there were illegal drugs back then, and in no time in history was there a blanket prohibition that prohibited a class of people from exercising their Second Amendment right, or any right, just simply because they used marijuana or an illegal substance. And now there were laws that prohibited you from being intoxicated and possessing a gun. But in this case, they never tested him. They smelled the marijuana, they found the marijuana, they find the gun. They never tested his sobriety to see if there was any impairment. So there was never any connection to his impairment. It was all just based on you're possessing this, it's illegal, bam, that's it. And so so the judge says, yeah, they go through and the case is, if you read the case, I've included it. It's 54 pages from the judge's ruling, but it's a beatdown of the state's argument about, well, there's this law and there's that law, and trying to pull all these different things in, and each one the judge is just like, no, that doesn't apply. And so it really goes to the power of like the Constitution, like actually looking back and saying the Constitution has power. Yes, you can restrain it in certain areas, but not like we've kind of become accustomed to just saying, well, Second Amendment is an absolute, so therefore anything's on the table. And with that ruling, it really strengthened, if there's going to be a law that's going to restrict the Second Amendment, there's going to have to be some sort of deep precedent from, it can't be from 1968. It's got to be like, much longer. And so that's basically,
or it has to have a substantial proven claim to public safety.
Exactly.
So exactly. And I think that's the key here. So there's takeaways. Takeaway number one, this is not a blanket permission to possess marijuana and guns. Like, that's not this. This is a district ruling, or federal district court ruling, which means that it has some implications for that particular case. It has some implications, arguably, for people who live in that district, certainly, but not beyond what the court specifically ruled in this person's specific instance. It certainly has no implication on impairment. So it doesn't have any implication on whether or not you can be impaired and be armed, only on whether or not possession of marijuana, specifically a controlled substance, is an issue. So more to come. I think if you're like, this is your hot topic and your hot button, I think the answer is keep an eye on this one, and we'll see what what else comes of this. If it gets appealed, for example, to the U.S. Supreme Court, that would change things, and that would be interesting. But for now, if that's your district, I suppose that's something to definitely be aware of. That if you're a weed smoking person, maybe you have some medical whatever need, or I don't know. Anyway, something to keep in mind. But I think that, the main takeaway for the community at large, Matthew, is what you said, which is we're seeing that the New York Bruin Supreme Court ruling from last year, it's reaching further than we would have expected in a good, positive way.
Mhm.
It's holding gun legislation and gun restrictions to a higher standard than we have had in forever. So the standards that it laid out that were applied in this instance were very high bars, right? If you're restricting the Second Amendment, one, is there some precedent for this same kind of restriction that existed at the time the Second Amendment was implemented, right? Is there some precedent for this back in 1700s and 1800s or something? With like, were we preventing people from exercising their Second Amendment rights then if they were using some sort of controlled, narcotic or drug or whatever the thing is? So if not, then that doesn't hold up to that muster. And second, is there some demonstrable public safety issue, right? Can you show me research data, et cetera, that's demonstrable, that is not overly prejudiced, that is, that's valid and good, that suggests that this legislation is important for public safety? If you can't do those two things, it just doesn't withstand muster. And we're going to see more and more of that kind of application of that legislation, that Supreme Court decision popping up in the future.
Yes, sir.
Good stuff. All right, let's balance on over. I'm actually going a little bit out of order, Matthew, just so you're aware.
Okay.
I want to do next the story from MLN about the federal court striking down the ban on Second Amendment rights based on restraining orders.
Mm-hmm.
This one is somewhat similar. At least it goes back to another question on the form 4473. So we're going to talk about this one next. So this is an article from MLN.com. These guys do a great job of doing stuff. And I'm a particular fan of this author. It's from Dean, who writes for MLN. And this is another interesting case. This is also from a U.S. District Court, the Eastern District of Kentucky, which is in Lexington. And let's see if I can get this one straight. You correct me if I screw this up, Matthew. We got our defendant guy, his name, let's see if I can find it. Combs, something Combs. I can't remember his first. Oh, there it is, Sherman Combs. Sherman Combs, he has a DVO, a domestic violence order against him, okay, effective June of 2022. And within a few days of that order being put into effect, he goes into a gun store and he buys 357 revolvers specifically. And when he fills out form 4473, he lies. He says on that form that he's not subject to a domestic violence restraining order. It's a question on the 4473. It asks it very pointedly. He lied on the form and said he was not subject to that restraining order. Now, obviously, down the road a little ways, so this comes up and we find out, oh wait, this guy's got a gun. That's going to be a problem, and so that's where the drama really ensues. And this thing gets, appealed and thrown around until it goes up to this federal court. And the defendant, Mr. Combs' argument is that, first off, preventing someone from buying or owning or possessing a gun because they have a restraining order is unconstitutional. And so for that reason, he shouldn't be able to be charged, arrested, convicted, whatever, for that crime, because the law that makes it a crime is unconstitutional. That's his argument. And then secondly, he thinks that, he was also charged with having lied on this form, which is a crime. And he's saying that, well, because the law that makes it illegal is unconstitutional, therefore lying on this form on that particular question is a non-issue, right? It's irrelevant, it's non-material, therefore I shouldn't be guilty of that crime either. So those are his arguments. Did I get it right? Roughly?
Yeah, absolutely. Yep.
So tell us what happened from there. What did the federal district court say to that?
Yeah, so initially he argued that, and the court didn't accept that, and then he appealed again, and it was a different ruling, and so one of the courts held that while the restraining order question or prohibition was unconstitutional, that he still lied on the document, and that's kind of where it was. But from reading this, it seems like that's kind of a stretch. That if really, if you have an unconstitutional law, you can't lie that that you can't lie because the law itself is unconstitutional that you're lying about. So that hasn't been, the case is still ongoing. But it's interesting, in I know sometimes even with the marijuana thing and this thing, people will push back and be like, well, people with restraining orders, domestic violence, abusers shouldn't have guns. But this is different. Like, we're talking about restraining orders where a person may not have even, like this restraining order, it says this type of restraining order, there's no court hearing, there's no attorney to be appointed for the person, a jury, or any sort of mediation that's trying to solve the facts of the case. It's just somebody comes in, they say this guy did this or that, he might not be there, ex parte, they issue a restraining order, and he's issued it. And so are we okay with restricting somebody's Second Amendment rights based on something that hasn't been adjudicated and there's no finding of fact to
there's
see
no
it?
due process.
Exactly. And I think that we all can agree that we don't want that, because that's a very slippery slope. Certainly we don't want people that have been violent and accused. I mean, those types of people, there's an argument to be made that those people have forfeited some of their rights by, not obeying the law, and whether that's a lifetime ban or you can rehabilitate someone. That's not the argument here. And my opinion on that is kind of irrelevant, but I think that this, I think that this is a good thing to say, look, if you're going to issue a restraining order against somebody, you need to have some finding of fact, to at least some level burden of proof before you start stripping people of their gun rights and then arresting them, right? And saying that they're lying on documents and federal felonies and all kinds of stuff, based off of just some restraining order, where sometimes these things, I mean, they people abuse restraining orders occasionally.
Former patrol officer Marister, you've seen that happen, eh?
You use the court system, right, to punish, your ex or your boyfriend or girlfriend or whatever it is, and it's a very sad thing, and it becomes very, very bad, and then you go to court, or there's a case and they drop the case because now they're back together, and they, he no longer hates her, she no longer hates him, and I was lying on that, and it's like, okay, well, we'll just make it go away. And it's like, you've already started this whole process in people's rights. So I think this is a good ruling. I don't know what's going to happen, essentially, or in the long run, but it's one of those things to watch, like you said.
It sounds, I mean, all of us, the gun community at large, does not love, respect, is not a fan of extreme risk protection orders, right? Red flag gun restraining orders, because they lack due process, right? Because we are concerned that anybody can say whatever, and without any due process, a person's losing their rights, potentially for a long period of time, or even permanently without due process. And so that's the core reason we have always fought back against those things and had a negative opinion about red flag laws, right? So all of a sudden, like, we're exposing, right? For me, this case is exposing that there's actually normal restraining orders. I mean, red flag laws aside, there's just straight up normal domestic violence restraining orders that lack similar due process. This guy, a couple of days later, he walks into a gun store. I don't know if he even knew that he had a restraining order. He actually, as it were, we do know that he knew, because it specifies that he knew. He admitted that he lied on the form, so he knew. But it's conceivable, right, that some court could be issuing a restraining order against me, and I could be going to the gun store the next day and not even know that I have a restraining order against me, because there was no due process. I did not have the right to face my accusers, to represent myself, or to plead my case. And so I think this is hopefully what I'd like to see come from this, is that we address some of these gaps in the justice system with some reform to make sure that people's constitutional rights are being met. Not only that we're not taking away rights, right, without due process, but remembering that due process is a constitutional right. one
Yeah.
that's just as important and just as enumerated in the Constitution as the Second Amendment, right? The right to face your accusers, to plead your case. That's as much of a right as the right to bear arms.
Mhm.
So anyway, I think what comes of this specifically. One last thought that I think is an important implication. The judge mentioned that regardless if restricting someone's Second Amendment right because of a restraining order is constitutional or not, one of the reasons that they upheld that lying on that form is a crime is because the FFL, who sells the gun,
Mhm.
has discretionary authority to decide to sell you the gun or not. Right? In other words, you can go into a gun store, fill out 4473, answer all the questions correctly, and the person behind the counter can say, you know what? We just don't want to sell you a gun. Hit the streets, bro. And FFLs have that level of discretion. They have that kind of discretionary authority. And that's an important thing to consider here. That, you might be thinking, well, maybe I do have a medical marijuana license, or well, the state has made it, okay for me to smoke marijuana, or yeah, maybe I have a restraining, or whatever thing you think is the case, but you choose to lie on that form, and that's going to be a crime. Like, I don't think that's going anywhere. Like, it's going to be illegal to lie on that form, and you need to understand that not only is it a crime, but you're also removing some of the discretionary authority that the FFL has when they choose to sell someone a gun. So that's not cool, man. Like, to me, that's like you're jeopardizing, as you're about to find out from another story we're going to read.
Yep.
You're jeopardizing our community. You are putting the Second Amendment at risk if you go in and lie on that form. You're not just putting yourself at risk as a criminal because you're lying on the form, but you're putting our whole community at risk because you jeopardize the authority of the federal firearm licensing system as a safe means to vet people who purchase guns. That's not cool.
Mhm.
Anything else on that one, Matthew?
No, you hit it.
All right. Well, then I think the next logical one, I'm still bouncing around our order. Let's go to another one from Ammo Land about the new leak that shows the ATF's plan to revoke FFLs. So all these links, guys, will be in the show notes, by the way. So if you're looking for you want to go read these stories or get more details, just go to the show notes when we publish the show, and it'll be there. Before we jump into the story, let's get our second sponsor message for the day. This episode is also sponsored by Guardian Nation. Guardian Nation is the fastest growing community membership program for defensive-minded firearm owners like you. You can learn more at guardiannation.com. Being a member of Guardian Nation is important because it's really, when we sat down and we worked out what was going to be included in Guardian Nation, we said, well, what does a gun owner need to be successful? And we identified all the obvious stuff. Well, you need a bunch of training, you need a bunch of education, you need the right tools, the right gear, access to the right information, those kinds of things. But what we really started to realize as we wrote all that on the board is that average gun owners don't have the resources to get all that stuff, not in any reasonable amount of time, because you have normal lives, right? Unlike Matthew and I, if you're listening to this, you're probably not full-time in this industry. And so you have a normal life with a normal job and a family and a lot to do. And so you probably don't have the time, and most of you probably don't have the financial means to drop everything and go get all the education, training, knowledge, gear, et cetera, that you need to be an extremely highly proficient and capable defender with a gun. And so Guardian Nation is meant to bridge that gap, to give you access to the training and education in a way that's convenient and extremely low cost, but also to give you access to the gear. Membership in Guardian Nation comes with a subscription box where we ship you gear 4 times a year, gives you discounts to product from our site and some other partner websites as well. It gives you all access to Guardian University, which is a place you can get all the training and video training that we have on our site, where you can pause it, watch it at your convenience, rewind, watch it again, watch it with somebody. It's an extremely efficient way to learn a whole lot of good knowledge and skill. It's just awesome. Check it out and learn more at guardiannation.com. And as a last note, we talked about Guardian Conference earlier. Members of Guardian Nation save somewhere between $150 and $200 on your ticket to the conference. So if you are a member of Guardian Nation and you go sign up for that conference right now, you're getting a screaming deal. Okay, because super early bird discount plus Guardian Nation member discount. Check it out. Membership, guardiannation.com. FFL.com. All right, Matthew. So this story, the headline is a little bit, I don't know, got a little bit of fear mongering going on here. New leak shows the ATF's plan to revoke FFLs, but it's not that far off from being like literally exactly what's happening. So give us the rough summary on this one.
Yeah, so essentially, FFLs, they are governed by the ATF and the license, and there are regular audits done on FFLs on their record keeping processes, how they're storing things, and it's very technical. It's very regulated, and those licenses are in, with certain violations, you can lose a license, you can have it revoked, you can have it suspended. And I know, Jacob, this because, our company just got an FFL not too long ago, and all of that paperwork and documentation you have to keep is pretty extensive. But what happened here is under the new administration, the Biden administration, the ATF adopted a zero tolerance policy towards violations at FFLs, and they spun this as, I don't know if you remember, a while back, there was a big push. There was a big push about, well, all these FFLs are, we're cracking down on these rogue FFLs that are selling guns to, gang members and not doing proper background checks. And so it really muddied the waters and kind of made it seem like, that they're doing a really good thing, which if an FFL truthfully is not doing what they're supposed to be doing, revoke it or suspend it, whatever, their license, great. But they kind of conflated the issue and kind of made it seem like all these FFLs, that any violation is like a violation of somebody who shouldn't have had a gun is getting a gun, or it's something nefarious. In most, I forget the percentage, but the vast majority of violations are clerical errors. And these are errors like, hey, you put the wrong date in a box. They signed in a box that they should have signed over here, or the person's driver's license was expired. You wrote down the date, but it was expired, and you didn't catch it. These types of things. And now, where before, the ATF representative for your FFL would come do an audit and say, hey, you got 4 of these violations here. They're clerical errors. It's your process. Let's look at how we can help you get better. Now what they're doing is, hey, you have these 6 violations. You're going to have a hearing here in a few months, and we're going to talk about possibly revoking your license. And so it's a very harsh standard. And I'm actually, it's funny that this story is here, because I'm actually speaking to an FFL, and I won't say who it is, in another state, who is going through one of these audits right now. And he's telling me that he's speaking to other FFLs, and this guy does about 1,500 transactions a year, and he had 6 clerical errors in that time period, and they are threatening to revoke his FFL. He's been in business for 30 years. All of them were clerical errors, and it's quite disturbing, because he's like, look, I want to get the word out, and my other guys that have FFLs want to get the word out about what's going on here, but we're scared, because if we start going to the media and calling our representatives, then what's going to happen? If there's a zero tolerance policy, everybody's going to make a mistake eventually. And if I have a target on my back from the ATF for my FFL because I called them out for targeting me, they're going to find something. It's just like your taxes, right? They're going to find some way that you violated something somewhere, and you're done. And so they feel like, they're very nervous about this, and this is being used to crush these small businesses, because they don't have money to hire attorneys to go through this audit process, and it's very expensive and time consuming, and it's really scary for these people, because they lose their FFL, they're done. And so this is this is a disturbing thing that not a lot of people are really hearing about.
Yeah. Having an FFL myself, though admittedly we don't do 4473s, we don't do transfers as a company. We don't have the FFL to be in the business of selling and transferring guns. That's not the reason we have it as a business. But that said, I'm semi-familiar with their compliance, right? Because I have to be compliant. And it's a mess. Like, if you're listening to this right now, you don't know, like, just, I'm telling you to take my word for it, that FFL compliance is a absolute master disaster. I mean, for me, it's probably the equivalent of an accountant trying to memorize the U.S. tax code, right? Like, that's what FFLs are trying to do to be compliant with the ATF rulebook. It is crazy. I mean, the 4473 itself, I mean, filling one out properly is like a masterful thing. Like, compliance on just getting 4473s done correctly and not having any errors there is crazy. I mean, we're talking about, if you really truly wanted to nitpick, I mean, when a dealer receives a gun, if that gun was manufactured in Austria by Glock, it has to be entered into their logbook differently than if it was manufactured in Smyrna, Georgia by Glock. So did they write Glock or did they write Glock Inc.? Because depending on the gun, you have to write Glock or Glock Inc. And if you write the wrong one, it's wrong. That's a violation. So I'm telling you that it is that level of ridiculous, nitpicky stuff that an FFL has to do to be compliant. Our friend of our business, Ryan Kleckner, he has a website, Rocket FFL, which you might check out if you are an FFL, if you're just having an FFL. He has a compliance course on there, which I took. I mean, it's unbelievable. I mean, hats off to Ryan for providing all that information, but it would take you days full time to sit there and go through the course just to understand how to be compliant with the ATF as an F. So anyway, I need to get off that soapbox. The point is, it's so easy for the ATF to find screw ups, to find, things that you did wrong, violations as they call them. And where previously there was some latitude to try and work with an FFL and help them overcome patterns or issues they were having, or forgive them when it's a one-off, the current administration is not having it. And here's the kicker. Here's the thing that I think you need to understand is the underlying thing. What happens when the ATF shuts down an FFL? Right? This is important. This is important because a 4473, when that's filled out and a background check is run for a gun purchase, the information that the state, feds, whoever is involved receives relative to that purchase is required by federal law to be destroyed within a certain number of hours. And they don't even receive like a serial number, for example. Is it a long gun? Is it a handgun? Who's buying it? Yes, they're approved. No, they're not. The detail you put on the 4473, the serial number of the gun and things like that, that's not going into some federal database. That's being, the FFL is required to keep it in their records, right? But it's not getting transmitted out when the background check is run. And even if it were, law requires that information be destroyed, not kept or registered or put in a database. But when the ATF shuts down an FFL, when an FFL ceases to do business, the ATF can and will seize all their records. And so those records become now the property of the ATF. And the ATF then has the right to database that information. So if you go buy a gun from a gun store today, okay, there's in theory no lasting record of that transaction outside of what the gun store itself keeps in their records. The government has no lasting record of that transaction. But if that gun store goes out of business, the ATF can seize all those records and keep them permanently. So right now, what we believe to be true is that there are warehouses full of all these records that have been seized from FFLs, that they haven't been digitized, that they're not in some digital database. But one, I don't know if that's true necessarily. And two, even if it is, that's not to say the federal government couldn't today go digitize all those records, right, that are sitting in whatever warehouse somewhere, like an Indiana Jones movie is what's in my mind right now. Mm-hmm. So anyway, it's a legitimate issue, not only because small business owners are losing their livelihood and gun stores are disappearing over ridiculous trivial things, not legitimate recklessness and negligence, but just failures to, to things like dumb clerical errors. But it's also an issue because this could lead to a massive database of gun owners and their guns that is not illegal. So, that's.
Mm-hmm. Yep.
Yep. All right. So speaking of FFLs and doing dumb things, let's talk about the dumpster diving. Matthew, give us that one.
Oh man, yeah. This was kind of thrown in there just for I don't know, maybe juxtaposition to the stories about guys, FFLs doing the right thing. And so here the article is ATF recovers 236 firearms from Oklahoma City dumpster. Now, this is kind of a weird story. Essentially, federal agents allegedly discover a dumpster full of working shotguns outside an Oklahoma City gun store. Apparently, one of the employees of this gun store was throwing functioning firearms in the dumpster, like not just one or two, but many firearms in this dumpster. And some
over
dude,
a period of time.
Yeah, for some time. And apparently some dude realizes there's guns in there and says, "Hey, can I have one? I just want to hang it up. It doesn't work, does it?" And he's like, "No, it doesn't work. And I just want to put it on my wall as a keepsake or some decoration." And he gives it to him. And so somehow the ATF catches wind of this, and
the garbage man tells him. The garbage
yes, that's
man
right.
Comes to empty the dumpster. And he sees the dumpster full of guns and calls the cops.
Right, that's right. So he contacts the ATF, and as the ATF is there, the dude who's like getting these guns goes up and basically says, "Yeah, I know about these guns. Like, yeah, I have a couple. You gave me some, and like, did you find? Is there a transfer involved?" And he's like, "No, I just took it, and no big deal." And so it's just a bizarre story. Right now, it says there are no charges have been filed against anybody here yet. It says there's like $100,000 worth of firearms that were recovered out of this dumpster by the ATF. And so it doesn't make sense. Like, why was this person just dumping firearms in, brand new functioning firearms into the dumpster? The ATF says that they were functioning. The guy who's throwing them away says they weren't. And so why?
A firearm, a federal firearm licensee, FFL can. There's a way to properly destroy a gun, and then dispose of it. And disposition is a very specific term in FFL language, right? It just means like remove it from my records and my inventory. So apparently this gun store had previously contacted the ATF about the proper way to dispose of a gun, and they supplied information about making cuts into the gun in 3 specific places: cut here, and cut here, and then it's good. you've destroyed it and you can dispose of it. But they're looking at these guns in this dumpster, and apparently there's some small percentage that weren't cut at all, and the majority of them were only cut in one place. And in many cases, that cut did not actually render the gun non-functioning. So clearly, this is an FFL who was not following the guidelines laid out by the ATF, constitutional or not, by the way. Just to be clear here, I'm not defending the ATF's guidelines or policies. I'm not defending the NICS system. I'm not defending background checks 4473s or the requirement to have to cut up guns to destroy them. I'm not defending any of that. I find all that to be ridiculous and unconstitutional. I am, however, simply saying that this dealer was clearly not following the guidelines that were outlined, and because of that, we have a dumpster full of mostly functioning guns behind the gun shop. And at least one guy who's dumpster diving and can't understand what the problem is. He was told that was fine.
Yeah. Weird story.
Crazy stuff. All right. Let's talk about Gun-Free School Zone Act of 1990, whatever it was, Matthew, and the havoc it's wrecking, the havoc it's creating, that works, for constitutional carriers.
Yeah, this is something we talked about before the show. And by the way, guys, we don't we read these stories beforehand, but we don't write down notes. This isn't a scripted show. This is, and whether some people like the format that we just kind of, is just informal. We're talking just like we're talking to you guys. And if we were having a conversation, some people prefer a more scripted show. This is not that. But before the show, Jacob and I were talking, and he mentioned that like he's been kind of screaming this from the hilltops for a while. And essentially, the Gun-Free School Zones Act of 1990 puts a prohibition 1,000 feet around school property, makes a provision for if you have a state issued permit. Now that, and again, we're not saying that that's a great law. We're not endorsing the law or that it's a good law or not. That's what is essentially is the Gun-Free School Zones Act. Now constitutional carry or permitless carry comes around, and now people are carrying, many more people are carrying firearms concealed in their vehicles, and they don't have a permit. And so they are not exempt from the Gun-Free School Zones Act. And you may not even know that you're in. You may know that you're in a gun-free school, in a gun-free zone, but you may not. And if you don't have a permit, it's no different than if you don't have to know that you're there. Essentially, it just being in the zone, de facto, statutorily, you're either in or you're out. Doesn't matter if you knew or not. And you could be facing some serious crimes. And essentially what ends up happening, there's a story here. If you read the story, there's a case that I kind of linked to, but and this is the whole argument, right? Like, well, if they don't know, how are they going to know? And what they don't know, won't hurt them and all that. But I think that there's some selective enforcement that goes on in school zones. Speed is a huge thing, right? And imagine, you don't realize that, you're going 26 miles an hour, or 28 and a 25 or whatever. You get stopped in that school zone. You have a firearm in there, and now you're in a state that requires you to notify the law enforcement officer that you have a firearm. So you're compelled to tell this person that you're violating the law, which there's some Fifth Amendment issues there. But it's a very easy way to end up getting caught up in this. And it's also, I believe, and I'm not saying anybody's doing this, but it could very well be an open door for some areas or municipalities that are specifically anti-gun or want to crack down on guns to target vehicles going through school zones. A hard policy on, hey, if they're going 26 miles an hour, we're stopping them. And they're required to tell us if they have a firearm, and we'll doggone it, we'll take, we'll get those firearms off the street. And, at the press conference, yeah, we took 6 guns off the street this week, and everyone's like, oh, great. Yeah. And they were in school zones. Oh, we're keeping the kids safe. And it could very well be spun up like that. I'm not saying anybody's doing it. I'm just saying the potential is there. And so this is one of those things that has to be on our radar.
Yeah, we have a very large number of states now that are constitutional carry, right? That no permits required to carry a concealed firearm. Basically half today of U.S. states are in that category, which is a significant increase compared to 3 or 4 years ago. And this has always been the case since 1990. Bill Clinton signed this law into law. I mean, it specifically says, I'm quoting now, quote, "It shall be unlawful for any individual knowingly to possess a firearm that has moved in or that otherwise affects interstate or foreign commerce at a place that the individual knows or has reasonable cause to believe is a school zone." And then there's other things that the law defines school zone. It says in or on the grounds of a public, parochial, or private school, or within a distance of 1,000 feet of the grounds of a school. And there's more. I'm not going to get into all the words here, but the short of it is that there are exceptions to this restriction. One of those is unless otherwise permitted by state law. And historically, that has been interpreted to mean having a concealed carry permit. Or if there were some other state law, I suppose, that specifically said, no, it's fine, you can have a gun in the school zone. Not aware of any states that have a law like that. So it's always been interpreted to mean, having a permit. So if you have no permit, you're carrying, under permitless or constitutional carry authority, and you're within 1,000 feet of school, and you're not at a private residence that happens to be within 1,000 feet of the school, you're just moving through that school zone with that gun. You're absolutely probably committing a felony. It's a little bit of a fear mongering thing. It's not our intent to be like, oh my gosh, everyone, like, they're coming for you. We're not aware of anyone who's been arrested for this. We're not aware of anyone who's been charged for this. We're not aware of people who are setting up stings in school zones for people who drive through that have NRA stickers or Marine stickers in their back of their window. We're just reminding folks that, in all the excitement around constitutional carry that took place, especially over the last couple of years, that you should probably be aware that people carrying under constitutional carry authority do not have the same level of authority as people with a permit. And this is one of those examples where you could be committing a felony with some frequency and not realize it. And maybe you're not concerned about it. Maybe you don't think you'll get caught, but at least we want to make sure you're aware that this is a potential issue. And it's one that has the potential to be abused by those who would target people like us.
Right on.
Good stuff, Matthew. Thanks for sharing that one. All right, let's move to the Federal District Court in Illinois. This is a good one.
Yeah.
So let me see if I can take us up a step higher from this and explain this. We got a bunch of anti-gun legislatures in this country, state level, federal level, city level, county level, all over, everywhere you look. There's people who want to take away our gun rights. And they are not creative people. They tend to follow the playbook provided by the people who want to take away our guns. That playbook sometimes is supplied by anti-gun institutions and organizations like every Town for Gun Safety or Moms Demand Action Against whateverness they call themselves. Sometimes it's provided by their political party. I'm not saying that any one group or political party is pro or anti-gun. I'm just saying that there's a playbook. And so if you're a legislator in Illinois and you want to stay in power and in office, and you need the support of your party to achieve that. Okay, that's the nature of our political systems. It's pretty hard to gain an office or maintain an office without the support of your party. That's not rocket science, right? And so if your party comes to you and says, hey, we want you to sponsor some legislation about getting rid of some gun stuff, I suppose you can have that fight if you want to, but if you say yes, they probably already have it drafted. That's why we see the same basic verbiage. Like, think about the extreme risk protection order crazy mania of the last 3 years. In almost every state, the legislation that was drafted and proposed was the same. It starts to get molded and tweaked as it goes through the legislative process, right? As it gets voted on and dissected, and there's debates that ensue, and it gets passed back between the House and the Senate and whatever. But pretty much it's a copy-paste book. And our friends in Illinois just found out that the copy-paste book may not work out well for you, because the biggest thing we know, I shouldn't say the biggest thing, but one thing we just know about anti-gun camps, people who are trying to take away our gun rights, is that they don't know anything about guns. Their fear is irrational and uneducated and uninformed, almost without exception. And this is no different, where in Illinois a law was passed at the state level to ban assault weapons, okay? But the law was vague and far-reaching, because guess what? They don't know what to write in there anyway. They're using the copy-paste playbook that was provided to them by the anti-gunners. And that copy-paste playbook is not specific for a large number of reasons, one of which is they don't know anything about what they're trying to ban anyway. Another reason is because you effectively can't ban the AR-15. It's too modular of a weapon platform. But anyway, that's a conversation for a different day. So they write this law that's extremely vague and far-reaching, to the degree that legitimately Illinois citizens would not have a clear understanding of what was banned. you wouldn't know if you went and read this law that was passed, that was voted on. You wouldn't know if your Remington 870 shotgun or your Mossberg 500 is now illegal. Like, it's that confusing or unclear or vague. And so lots of lawsuits were filed. But tell us about this particular lawsuit and how that's going to shake it out a little bit, Matthew.
Yeah, what makes this kind of unique is, well, there's actually, I believe there's many lawsuits, but one of them has to do with the component of the law that bans firearm components like parts. And so you can't even have parts of guns that could be used to, make it fit into one of these broad, vague categories. So it's so vague that even, you might have a type of a spring or a sear, and these things could be illegal to own of themselves. And so the interesting thing is, what they did was the attorneys said, okay, or actually the attorneys asked for an injunction against this law. The judge granted it, the court granted it, but there was a period of time for the state to appeal that and say, hey, we don't think that you should
this injunction is unjust.
Exactly. And so the judge's like, okay, that paperwork, that argument that you're going to bring, I want you to give me an example of everything that is going to be in violation. Not just, and he leaves it very vague, so as to say, you need to provide an example of everything that's going to be illegal, meaning every spring, every sear, every part, every gun, everything, every stock, every foregrip, everything, which is impossible. And it's pretty, kind of not entertaining. It's sad because it just shows that, like, there's no way that they would be able to bring examples and show all these things. But it's true. Like, if you're going to ban something and make it illegal and strap felonies onto people, you need to be clear with what you're banning. And I think the point of it is the judge is like, you don't even know what you're talking about. I know what you're doing here is completely it's vague and it's ridiculous. And so I'm going to, make a fool of them by saying, okay, show us all the things that you're going to ban. And it's impossible that they'll be able to do all that. And so the idea is that this potentially the state will just be like, okay, we can't, and we'll have to redraft the law, or we'll have to go back to the drawing board, or because it was already signed. It's not a bill, it's a law. So they might have to, amend it or just kill the whole thing altogether, which probably wouldn't happen. But it's just an interesting tactic or an interesting thing that, typically we don't see.
Yeah. 13th of February, 2023, order from the court. Within the response to 16 motion for preliminary injunction, defendants shall provide illustrative examples of each and every item banned under 720 ILCS. Signed by Judge Stephen McGlynn on February 13, 2023. This text entry is an order of the court. No further documentation will be mailed. So I love it because I think it's going to have two important repercussions. First is that this Illinois law is going to effectively become defunct. They'll have to change something, do something, junk it, start over, something. I mean, this is proof that this temporary injunction is effectively going to become a permanent one, because they just realized how faulty the original law is in its lack of clarity or whatever. But the other thing it's going to do is it should have an impact on the playbook, right? For anti-gun organizations who draft this crap and force their local representatives to push it onto the legislature. This is hopefully they're going to take a step back. I'm like, crap. Like we've been trying to throw vague stuff out so that it would leave us enough maneuverability to, make everything we want illegal. And this, in Illinois, it didn't work. The court's pushing back. And so we're going to have to change tactics a little bit. And I think that that's an important thing. It's an important thing, not just because gun owners deserve specificity. If you're going to ban something and call them a criminal, you better be clear on what the crap you're banning.
Mm-hmm.
But it's also important because at the root of these assault weapon bans and laws like this is a significant weakness that they know is there, but they don't understand because of the lack of understanding. And that significant weakness is the reality that you can't ban the scary rifles without banning all of the not scary guns that your constituents will not allow you to ban, right? You have a certain amount of your constituency which is in favor of getting rid of the scary rifles. But when pen comes to paper and you actually have to write that into a law, you find out when you try and be specific, you can't. Not without getting rid of all the normal, not scary guns that by banning your constituents will yank you out of office for doing.
Mm-hmm.
And that's at the root of this.
Yep, absolutely.
Oh, super fun. All right. Well, speaking of lawmakers and see how I've had some really good solid transitions this episode.
You have, yeah.
Like I feel like it's flowing really good between stories. See how we did that just again? Speaking of lawmakers, let's talk about Angie Craig from New Jersey,
mm-hmm. and
the very unfortunate thing that happened to her recently that's got her rethinking some of her policies.
Yeah. So I don't know if you guys have been following the past few years, but it seems like there's been a little bit of increase in criminal activity and property crimes and things like that across the country. And so recently, I don't know if you guys followed this, but there were 2 Republican council members that were killed in New Jersey. Separate incidents. They were shot different. It doesn't seem like they were targeted because they were Republicans. At least that's what they say, and they weren't connected. But there have been some assaults in the past. Obviously, Scalise and I know Pelosi's husband isn't a congressman or a politician, but there's been some violence towards politicians, probably since the beginning of time, right? Anyways. 2 Republican council members get killed. Just last week, a Democrat representative, Angie Craig, gets assaulted in the elevator inside her apartment building in the Capital City apartment complex in Washington. She escapes. She's unharmed physically, but shaken up. And so what ends up happening, though, is kind of interesting because she was somebody who pretty much towed the line of, we need to defund police. We need to, look at, criminal justice reform as far as bail reform and sentencing and all these things. And after becoming a victim, after being victimized by a lunatic who should have been in jail and locked up, he had been, she was his 13th assault victim. He had been arrested 12 times for assault. She's the 13th. And so this experience kind of opens her eyes and is like, oh, wait a second, and kind of changes her whole paradigm of, well, maybe these reduced sentencing laws that we thought would be great because it would make everything good. And everybody's saying that the recidivism is going to go up, this is not going to be good. And we're going to have people and everybody denied it and said, no, this is a great idea. She realizes, no, that guy absolutely should have been in jail. She makes some pretty bold statements about, she says, I was assault number 13 on his record. I'm going to do everything in my power to make sure there's not a 14, a 15, a 20. If you throw someone in jail for 10 days and think there's your punishment and we're going to let you right back out on the street, what the hell do you think is going to happen? And I mean, she's right? But it took her becoming a victim. And I think this is the disconnect that a lot of lawmakers have, that they don't really they haven't, they're not in the areas that their constituents are and being faced with violence. And when you say like, oh, guns are, bad, we're going to take guns away, a lot of times it's those violent communities with a lot of crime that those people need firearms to protect themselves. And so when you become a victim, you see violence in crime totally different. And I probably disagree with her on, many political, ideas and stances and things, but I do at least give her credit for standing up and in saying, I was wrong. I think that this is my view has changed on this, and I think that that's a good thing.
Yeah, I admire anybody who does a 180 on anything they believe, because it's so hard. It's so hard to change a belief. To say I feel firmly about XYZ thing, and to say, you know what, I changed my mind. Changing your mind is a very difficult task. It's just not something humans are particularly good at. So I think anytime someone can have an experience that causes them to question their own belief, and that they take that process seriously and they change their mind, props to that person. And I think that it's worth us asking the same question about ourselves, right? Are we open-minded? Are we willing to look at evidence and information that comes in that questions our existing beliefs and take it at face value and really think through it and question ourselves on a regular basis? Or are we closed off like, no, I'm for sure right, nothing can change my mind? So props to her for that, for sure. And yeah, this guy should not be on the street. Like, there's no, I think he needs help, by the way. I think an unfortunate reality is that sometimes legislatures are limited in what they can do. And so sometimes they try to apply band-aids instead of looking at underlying problems. And because it's easier, or it's the only thing that's within their power to do it. It's not one of our news stories for this week, and so I'll just mention this quickly, but I can't talk about this without laughing. There's a representative in Illinois who's proposed a bill that would require certain business owners of certain business categories who live in certain population dense areas to have private security. One of those categories is convenience stores and gas stations. So we have a legislator in Illinois who's saying we should require these small business owners who are operating on very tight margins, and in many cases barely making it, we should require them to hire armed security so that people can safely fill up with gas without being assaulted. Like that's the solution, right? Like, so we fail to sometimes look at the underlying problem. Look, well, maybe we should do something about the crime. Maybe that's the cop's job and not the job of the business owner if people can't feel safe filling up with gas. Before that, we also had Operation, what was it called? Illinois did pass, I can't remember if it was an administrative thing or a law, but there was a couple of communities in Illinois, Operation Fuel Pump or something like that, where they had designated times of day on certain days of the week. On Thursdays from 1 to 3 p.m. or whatever it was, we're going to have cops at X or armed security at X gas stations so people can fill up with gas without fear of being robbed or shot. Like that's the kind of thing like that we're trying to put band-aids on a problem, right? So going back to what happened to Representative Craig, I'd like to believe that she's saying, you know what, we can't keep putting band-aids on the problem. We need to address the issue. And there's different layers of that, because she, in addition to talking about longer sentencing and repeat violations and things like that, she does also talk about mental illness and some other things like that need to be addressed. This person is not stable. This person is a lunatic. They need help. And maybe help is not just prison. Maybe there's something more society can do for this individual. And so I appreciate that tone as well, that we need to look beyond the surface level of this, which is throw more people in jail and keep them there, repeat offenders. And we also need to say, well, what can we do to help these people? Because just locking them up and making them a burden to taxpayers maybe is not the long-term solution to this, this issue in society. So a bit of a long-winded thought there, but I think it's important.
No, that's good. Yeah, right on.
And if you're in Illinois, call up that representative who wants to force small business owners to pay for armed security and tell him he's a moron.
How ridiculous.
It's just unbelievable. Just like, okay, so I guess we've just admitted that we can't keep people safe. Got it. 10-4. Like, thanks. We're just going to throw in the towel and be clear that, hey, we can't keep you safe.
I wonder if the state has an armed security that we could hire. Can we do that?
Government contract time.
Yep. There
That'll
we go.
keep me in power when I need votes again.
There we go.
All right. Well, that's it, guys. That's a wrap for us today on Season 8, Episode 5 of the Concealed Carry Podcast. Remember, this episode was sponsored by the Guardian Conference and by Guardian Nation. Check it out, Guardian Conference. That's where people go to get affordable, awesome training from the best trainers in the nation. Matthew and I will be there, though we won't be training. Most likely Matthew might, because he's pretty awesome, but I won't be training. So we'll be there. I'm excited to get some education myself. Check it out. And, of course, always learn more and join Guardian Nation at guardiannation.com. We appreciate all you guys participating today. Please leave us a review if you haven't already. If you have feedback for us, things we can improve, topics you want us to address, you can always email us at podcast@concealedcarry.com. We do read and respond to those emails every time. So thanks again for being with us here today and for letting us feel your ears for an hour or so. Matthew, I appreciate your time.
Thank you. Thank you, Jacob.
All right, with that, we're signing off. Remember to train right, train often, train safe so you can fight hard, fight fast, and fight true. Take care.